Hello, hello. Good afternoon, everyone. I hope you guys are doing great. It is Wednesday, March 26th, 2025, and I have a great topic for you guys. So please join me. Let me know where you're joining from. And for those who are just joining me for the first time, let me introduce myself. My name is Ifama Odunlami. I am an immigration attorney from the Odunlami Law Firm. We are located physically in New Jersey, but we serve clients in all 50 states. As long as you're looking to get legal status in the United States, we're here to assist you. Assist you to get legal status, assist your family members to get legal status. And so my background is a little different today because one of my computer screens basically just blinked out on me. So this is you're seeing a bit more of my office. So thank you guys for joining me. I have somebody from American Samoa. Well, from Houston, Texas. And hi, Mohammed. Hi, Akin. Nice to meet you guys. So you guys can hear me. That's excellent. I'm on Facebook, I'm on Instagram, I'm on YouTube, and I am on TikTok. So the topic I have today is let's talk about what is going on at the border, the airports, the people who are driving in, but typically the airports. That's where we're getting all these stories. We're talking about the fact that people who have legal status, maybe they went out with advanced parole, maybe they went out with a green card, they are coming into the United States, and some of them are being detained. Some of them are not allowed to come in. And really, the law regarding what's going on is now in a flux. Nobody knows what is going on, what to expect. So what I want to talk about today is what to expect. And in the abundance of caution, what we're telling our clients, if you're a green card holder or you have a non-immigrant visa, even if you have advanced parole, this is probably not a time to travel because no one can guarantee you that you're going to be able to return. There is for green card holders, you may be put in removal proceedings when you return. We're not sure what's going on. So until we have a definitive idea of what rule of law is being followed, we're advising people to either talk to your attorney, who will update you as to what's the current status is with regards to people who are traveling, or you defer the travel until there's a little bit more, a little bit more information about what the rules are with regards to travel. So I prepared a little document which basically talks about what to expect at the border. And so if you like I said, my office is in New Jersey, and I know people always ask for my number, so I'm going to give you my number right now. I'll give it at the end again if I remember. So the office number is 973-993-1900. Please call only that number because there's a lot of people scamming other people, scamming immigrants, pretending to be our law firm. They're reaching out to people on social media. The best way to reach us is 973-993-1900, or you can send an email to support@odunlamilaw.com. So let's talk about what to expect at the border. What are your rights? Quite frankly, CBP, Customs Border Patrol, has a lot of rights with regards to who they let into the United States. They have a right to search your person. They have a right to search your luggage. They have a right to search your phone. So back in the day, really before we got the smartphone, before we got computers that can do so much and can reveal so much, pretty much you come to the airport and they search your luggage to make sure that you don't have contraband, and that's really it. But today, your smartphone can give your life history. It can tell anybody who's looking what your financial history is, your educational history, your medical history, your marital history. Everything is on your phone, and also probably on your computer. So when you're coming to the United States, right, your rights your right at the border depends on what your status is. It depends on whether you're a US citizen, whether you're a green card holder with a 10-year green card, whether you're a green card holder with a conditional green card, which is a 2-year green card, or whether you have a non-immigrant visa. So let's start from the beginning. If you're a US citizen, what do you expect? Now, as a US citizen, CBP really can only ask you questions about your identity and your citizenship. Those are the questions you have to answer, really, quite frankly. However, if you don't answer other questions, they can detain you for a while, right? So it can make things complicated, but they cannot stop you from coming into the United States because you are a US citizen, right? Now, let's talk about, so CBP must allow US citizens to enter the country, okay? That's clear, right? Now, CBP can conduct routine searches of baggage, electronic devices, and your person without a warrant. They can. Well, it also depends on where you're coming from, because I know maybe New York has said you cannot, it violates the Fourth Amendment to search electronics, but let's just assume that they can search any of this. CBP can search your baggage, they can search your electronic devices, they can search your person without a warrant. Now, if they want to do a strip search, they require reasonable suspicion, right? Now, as a US citizen, you have the right to refuse any questions beyond confirming your identity and confirming your citizenship. However, like I said, if you refuse to answer the questions, they can detain you temporarily. If you refuse to allow them to search your phone, they cannot force you to give your password. They cannot force you to provide to unlock the device. You can refuse to do so, but they can take a hold of your device and send it for further inspection. So those are the things they can do. They cannot stop you from coming into the United States as a US citizen, all right? Now, green card holders. Green card holders could be 10 years or it could be 2 years. Now, the thing you need to know about green card holders, if you have a 2-year green card, which is a conditional green card, right? If your removal of conditions is denied before you get to the airport or about the time you are seeking entry into the United States, if it's denied, they don't have to let you in, right? So if you have an I-751 pending, you want to know that, all right? Now, if you have a 10-year green card, you have a right to enter the United States, because even if there's any issues with whatever it is you're doing or not doing or what they saw, they have to let you in, but they can refer you for immigration proceedings. They can put you in deportation hearings. They have to let you in, but they can put you in deportation proceedings. So, similar to US citizens, green card holders can be subjected to searches. Let's just agree that everybody can be subjected to searches, okay? Now, unlike citizens, refusing to answer questions can lead to further scrutiny and can even lead to a green card holder being placed in removal proceedings, right? So, also, even though you have a right to come into the United States, CBP can question your admissibility. Are you admissible based on, do you have criminal records? Do you have any issues with fraud? Or have you stayed outside the United States for more than 6 months, right? So, same as citizens, CBP can inspect without a warrant, but they cannot force you to provide passwords. But the same things happen. If you don't provide your password, they can take your device, and they can, have it. It can be put away for further scrutiny. All right. So let us talk about rights of non-immigrant visa holders. I mean, visitors, students, workers, H-1B, L-1, all of the like, non-immigrant visa holders. Now, having a visa does not guarantee you entry, as you can tell from the Rhode Island doctor who was turned back. I think she had a work visa, and CBP claimed that they saw text messages, or she had gone to the funeral of a Hezbollah leader or something, and they turned her back. They deported her, right? Now, we're also finding that some people, instead of being deported, they've been detained, put in detention hearings for 11 days, for 18 days, and those detention facilities are like jails. They're not comfortable. I think there was somebody from Canada who said it was, there were like 30 women in one cell. The lights were on 24/7. They didn't have they weren't able to go to the bathroom as often as they wanted. They were fed once a day. So it's not fun. So that's why you need to take this seriously, okay? So holding a visa as a non-immigrant visa holder does not guarantee you entry into the United States. CBP has the discretion to deny your entry, and they can do an expedited removal where they turn you back, or they keep you in the detention for a while and then turn you back. Now, CBP can conduct searches and ask extensive questions about your travel plans. Why are you coming to the United States? How much money do you intend to spend? Who are you staying with? And sometimes, based on your answers, they can reach out to the people that you have said that the people that you've given them as references as to where you're staying or what events you're attending. They can reach out to them and ask them those questions to confirm that what you're saying is true. Or they may choose not to even ask them any questions. They can choose to just turn you back. So definitely, if you refuse to answer any of the questions they're asking you, you will be denied entry. No question about that. So CBP can inspect without a warrant, of course, and refusing to cooperate may lead to visa cancellation. All right. So like I said, you can be subject to expedited removal, and you have very limited options for appeal, if any. So due to the fact that there's a lot of uncertainty at the border, I'm really suggesting that this may not be the time to travel unless it's an emergency. And if it's an emergency and you need to travel, I recommend that you talk to a lawyer first so that they can discuss with you what the risks are, because there definitely is a risk. All right. So I think that's all I wanted to talk about. So actually, one more thing. So let's talk about, if you want to travel, how do you travel in a safer manner? So these are best practices for travelers. Coming to the United States and you meet a CBP officer, you want to always be polite, right? Polite and cooperative, all right? Understand your rights, as I've discussed, right? Travel with minimal sensitive data on electronic devices. And I reviewed what the advice is out there for people. They're saying, don't carry your cell phone because, don't carry your cell phone. Maybe some people are suggesting you have a burner phone. I don't even know what a burner phone is, but I guess if you want to get it, you will figure it out. Delete all social media apps and bank apps that give them a window to your life. Delete photographs that give them a window to your life. Turn on two-factor authentication and encrypt as much as possible. So that's really what the advice is with regards to traveling outside the United States. So I'm going to answer some questions on, hang on guys, on social media. And Mohammed says, can T visa holder be expected to pursue the green card process under the new law, please let us know. There is no new law, Mohammed. It's just that the law as we know it is changing a little depending on what pathway you're proceeding on. So to my knowledge, there's nothing. T visas can still apply. I mean, T visa holders can still apply for a green card when you've been on T visa holder for 3 years, or you can even request it be done earlier if you qualify. If you're applying for a T visa for the first time, you definitely can go ahead and put in your application. VAWA is still the same. There's really not much difference, except that I think there's some news that came in yesterday that some adjustment of status applicants are some adjustment of status applications are being held for further scrutiny. It's not clear what that scrutiny is, but what it's clear is it's going to be delayed. Delay. It doesn't tell us whose adjustment of status application is going to be held. So that's news that we just got yesterday. And so my thing is this, because I know a lot of people are worried about applying for immigration processes. If you have a pathway, you should apply, because if you don't, you're really a sitting duck. If you don't apply for a pathway and you're picked up, there's less basis for getting you out of detention. There's less of a basis for getting you out of detention. Of course, there's no guarantee that just because you have an application pending, that will, get you out, bond you out. But it's better than not having an application. And if you don't know if there's a pathway for you, I always tell people the best thing to do is to reach out to an attorney. I've done several consultations where people have been here for over 20 years and they have been told that they don't have a pathway. I screened them and I realized that there's a pathway. They have a T visa. They could apply for T visa, or maybe they already had a application process for them and approved for them that they didn't realize that they were actually U.S. citizens. So it's important to talk to an attorney and get, at the very minimum, get information, know what is going on with your case, know the difficulties in your case, right? I've had people who didn't realize that because they were a victim of a violent crime that they could apply for a visa and get a green card. All of these are pathways. Now, what really makes me happy is when people tell me that they listened to one of my videos and realized that there was a pathway available to them, and they came to me and we talked about it, we put the case through, and they won their green card. So it's important to keep your ears open, listen to the news, objective news, reliable news, and follow attorneys that you know that are giving you accurate information, because there's a lot of people on, social media just saying things that are not strictly true, but could be misconstrued. So just, let me take another question. So let's see. Automechanic says, my consular process has been on administrative processing for over 6 months. What should I do? Well, Otto, I'm not sure why they put you in administrative processing, but typically what we do in this situation, after we talk about your case and figure out what's going on, we want to see if you are somebody who could file a lawsuit to get your process moving. Now, filing a lawsuit does not guarantee you that you're going to get the answer you want, but it will guarantee you a decision. They'll make a decision, yes or no, okay? And sometimes that's what people want to know, yes or no. All right, so Akin says, can someone who came through the border marry a U.S. citizen and not go back to their home country? Is it possible to adjust status after you marry and not go back to your home country? Akin, only in limited circumstances. So let me explain this. If you come through the border and you're not, you come in without being inspected, without being admitted, without being paroled in, you enter without inspection, we call it IWI, then you marry a U.S. citizen, you're not going to be able to adjust your status because of the manner of your entry. Now, there are humanitarian pathways that don't care about your manner of entry. For instance, if that spouse, your American or green card holder spouse, is abusive to you, or you have a child who's over the age of 21 who's a US citizen and they're abusive to you, or you're a child and you have a parent, step parent, who's a US citizen and who has been abusive to you, you could file under VAWA, Violence Against Women's Act, and that would allow you to adjust your status and get a green card without having to leave. Now, the same applies for people who are victims of trafficking, labor trafficking, sex trafficking. Same applies to people who are victims of a crime, a qualifying crime, right? And that's called the U visa. Subject to these three, and maybe an asylum as well, right? If you're coming through the border, you are going to need to file a waiver if your spouse files for you. When the waiver is approved, you have to depart the United States and go for your interview in your country at the United States embassy in your country. And then when you go through that interview and you're approved, then you come back. And that's not as scary as people think it is. But the important thing is, before you leave this country for any reason, you need to talk to an attorney, because even if your 601A is approved, which is the waiver is approved that allows you to leave and come back, if you've committed some kind of crime, the 601A does not cover crimes. And so you leave the country and you're stuck. So again, it's important to reach out to a reputable attorney that you trust, is knowledgeable as well, and make sure that they understand your situation so that they can advise you properly. If you need to reach us, call us at 973-993-1900. So let me answer a couple of questions from Instagram. All right, Instagram. All right. Okay, Osaken says, my brother already spent more than 1 year outside of US and he's a green card holder. So Osa, if your brother has already been outside the United States for more than 1 year, there's a presumption that he's abandoned his green card, quite frankly. So without knowing more about your case, I mean, there could be, there might be things that he could do, but you would need to talk to an attorney, because when we don't know why he spent more than 1 year outside, you do need to ask him to reach out to an attorney and let them review his case and figure out if he can be assisted if he wants to come back. I mean, some people stay outside for 1 year and they come back and CBP lets them in and puts them in removal proceedings, and there they can defend their case. That could also happen, yeah. So, all right, let me look for another question. Okay, Christopher says he has a second interview, adjustment of status. So you have a second interview, which is it a marriage case? If it's a marriage case, I suspect it's going to be a Stokes interview, which means that they will separate you and your spouse, and they will ask you questions, and they want to make sure that you and your spouse, your answers are similar, because they want to make sure it's a bona fide marriage and that you didn't enter the marriage to evade immigration law. So what I'm going to advise you is you want to talk to a lawyer and have a lawyer go with you to the interview, so that the lawyer can be in your interview and your spouse's interview, and will be able to give you more information about what both of you said, okay? Chimi says, can a U.S. citizen parent file for DACA adult recipients? So the thing is, when you're over the age of 21, right, the answer is yes, but it's not an easy process. When you're over the age of 21, because you're an adult DACA recipient, you're on a preference, which means that there's not a visa immediately available to you. And in the preference list, you have to be in legal status to be able to adjust your status, right? If your parent files. So the parent can file, yes. But the question I ask is, has that adult DACA recipient ever had unlawful presence? So if they've had unlawful presence, they're going to need a waiver and they're going to need a consular process. All right. And if they have not had unlawful presence, they will need a waiver, but they will need a consular process, which means they just need to go out and consular process and come back in. So the important thing is that you need to know whether that DACA recipient has unlawful presence. Unlawful presence means when did they get their DACA? Did they get approved for DACA after the age of 18? Then they have unlawful presence, okay? So Elsie Baboit, you would like to file for your children, you're a green card holder, you definitely can file for your children as long as they're single, all right? You can file for your children under the age of 21, you can file for your children over the age of 21, but they have to be unmarried. And of course, because they're also on a preference, there's a wait, all right? All right. So Evolution of Life says, what about women who face genital mutilation? So you're talking about female genital mutilation. What about them? If you're here in the United States because you've had a female genital mutilation, you know, which is, you know, past persecution, and you have, you know, you may be able to file asylum if you meet other qualifications. But make sure that if you're filing asylum, you're filing within a year of coming to the United States, okay? Somebody says, is it possible to come with VS? What's VS? And so somebody says, what if you have a disorderly conduct on your record and a previous denial of naturalization due to moral character? Secondly, they said it wasn't within the time frame of 5 years. So CEO Queen, if you apply for naturalization and you have a disorderly conduct on your record, yes, that would be a problem for moral, proving that you're a person of good moral character. And you do need to talk to an attorney so that they can look at that disorderly conduct. And if you typically with naturalization, there's a 5-year look back period. But even if it's over 5 years, USCIS still can look beyond that and deny you. So you want to talk to an attorney to see if they can prepare a really strong case showing that you are a good person and you're deserving of getting your citizenship. All right. So let me look at I'm going to look at, you know what, I'm trying to go to TikTok, but hang on, TikTok. Oh, my nails won't let me be great. So, all right, let's see if I can answer a few questions on TikTok. Let's see. So, Vivacious Lady says, a friend overstayed her visa and has gotten married to a US citizen. Can she adjust her status? Typically, you should be able to if you don't have any inadmissibilities. So that is a person that needs to talk to an immigration attorney so that they can ask her some questions and make sure that she doesn't have any other inadmissibility. And also, of course, you know that if you overstay your visa and you get married to a U.S. citizen, USCIS will be looking at whether you came into the United States fraudulently with intention to stay, and that could go to fraud, which could be, which could be a basis to deny you. So those are things you want. Of course, you could file a waiver if they find that, or there's some kind of fine or fraud. But you do want to talk to somebody. Your friend needs to talk to an attorney to make sure that she can file without a problem. Okay. All right. Let's see. Corinne Smith says, can TPS holders travel outside of the United States I don't advise that at all, because clearly, if you have, you can, but not in this administration. Typically, you could in the past with the right documents, but right now, I don't advise that. So Kingzo says, can a green card holder stay outside the United States for 9 months? I mean, yes, you can. Typically, if you stay outside for 6 months, there's a presumption, but it's a rebuttable presumption, which means you can explain why. Now, if you stay after a year, it gets more complicated, okay? But if you're a green card holder, I'm going to say you want to start trying to come back, because we're not sure what's going on with the rules. Yeah, Vijama says it's not easy to talk about abuse from your child. It makes you look like a bad parent. Honestly, Vijama, you're so correct about that, because I have found that a lot of parents who have U.S. citizen adult children they feel guilty discussing the abuse they suffer from their children. They feel guilty, and maybe some of them feel that it makes them look like bad parents. A lot of them just don't feel that they should talk badly about their children. So that's a case type that it's really hard to get that story out of the parents. But I think if this is a pathway, this is something that is available for somebody, a parent who has been abused by their child, to get a green card through that because of that abuse. And that would be VAWA. And VAWA is confidential, so your child is not going to know. And it might be easier to make this decision when you talk to a lawyer, because being in legal status is really important. It's really important. And VAWA, the good thing about VAWA is it's really helpful for people who came in at EWI, which is entry without inspection, because they're not disqualified from getting a green card because of their manner of entry. All right. Let's see. So Naxi says, how long does it take to get a fingerprint from T visa? Me and my 2 kids filed for it, but my son already did his fingerprint in December, and no response since then. Naxi, I don't have an answer to that. We're also seeing that there's been quite a bit of delay in some processes, and I would say call the customer service number. And make sure that you haven't changed your address, because sometimes they send us stuff and people have moved. So do an inquiry, call them and see what's going on. Okay. I wouldn't be too worried. I'd wait maybe 3 months, 4 months. But we're noticing some delays as well. So I don't know what that's about, quite frankly. All right. So in Mother Earth says, my I-130 spouse applied in 2023 and still nothing. That's a long time, because we're in 2025 now. I mean, it's taking a while now. Recently, I-130s are taking over a year, but 2023 to 2024. I mean, do an inquiry, okay? Because it depends when in 2023 you applied. If it was the end of 2023, you could be expecting a response right about now, okay? So Benson and Kindley says, can I travel again this year as I have traveled last year twice, approximately 3 months? Benson, if you're a green card holder, which I'm assuming you are, and you're traveling in and out of the United States for long periods of time, just expect that CBP might be asking you questions about why you're staying outside the United States for 3 months, 6 months, really, in a year. That's what it is, because you say you traveled twice. You're kind of cutting it, okay? So I think you want to be careful, because, like I said, we're not sure what the rules are anymore at the border, okay? All right, guys, what else? Let me see. I'll answer a couple more questions on Instagram, and then I'm going to head out. So yeah, 0230 says, my husband filed an I-130. Can I file I-485 and I-765? If your husband is a U.S. citizen, then you can you can file an I-485 and I-765. Actually, you could have done it at the same time in one step. But if your husband is not a U.S. citizen, he's a green card holder, you can file an adjustment of status unless you are in legal status and you have always been in legal status, okay? All right. All right, one more question. So Mayor 381 says, good afternoon, I filed for VAWA, but now my husband came back begging me to forgive and we should live as family again. So my question is, can I change my petition back to marriage based? Well, Mayor, I don't know the strength of your VAWA case, but I'm assuming that there was abuse in this case, because otherwise you wouldn't have filed a VAWA, right? So if there was abuse in this case, and this is not legal advice, I'm just telling you, when we have clients who were abused by their spouses and then they make up, I typically advise them to go ahead with their VAWA case because the abuse did happen, right? And the thing about abandoning your VAWA case and filing another I-130 petition is you put yourself under the power and control of your abuser. Because if your abuser decides not to proceed with that petition, you're screwed because it's their petition. So VAWA allows you to self-petition. So even if you and your spouse are living together and are back together and everything is hunky-dory, the important thing was that at the time you filed the petition, it was a bona fide marriage and you were abused in that relationship. And you can tell your story and you can back it up, okay? So, okay, guys, I think that's it for today. If you need our assistance, we're here to help our fellow immigrants get legal status so that they can live in the United States without fear of deportation, without fear of family separation. So the number to call is 973-993-1900. Take care, everyone. Bye-bye.